Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville Workers Compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Welcome to episode 6. Today, we're in the studio with Louisville Workers Compensation attorney Scott Scheynost, and we're going to talk about the workers' comp claim process, kind of an overview of this entire journey that you and Scott are going to walk together. And Scott, welcome back. Hi, good to see you.
Really glad to be back here. Good to see you, Jim.
Absolutely. Now, we have talked, or you've actually educated me on this. There's an informal and a formal process. Do you kind of want to give an overview of what that means?
This is how I conceptualize it, and if you're as crazy as me, you might be able to understand this. The way I break it down into the claim procedure is that there's an informal process and a formal process. Well, what does that mean? Well, the informal process is really the beginning of your claim. When you're working on it and you're dealing with a claims adjuster, you may not even have an attorney yet, but you've reported it, they're paying benefits, it's going on. You're getting stuff really without forcing them to do anything. That's what I call the informal process, and I'll talk about that a little bit more in a second. The formal process is what a lot of people call litigation. When we've not been able to resolve your claim through the informal process, we have to go in front of a judge, and that's the formal process that we go through to get you benefits, and we're actually forcing your employer to do something. So what I would like to break this down into those two sections, the informal and the formal. Most people think of the informal process as a workers' compensation claim is all they have to actually do. That's when you've been hurt at work, you've told your boss about it, you've given them notice. The boss has turned it into the workers' comp insurance company. The workers' comp insurance company has assigned an adjuster to it. The adjuster is giving you a claim number. The adjuster is paying for your medical treatment, paying for your medical expenses, mileage you go back and forth. You might be off work. You're getting money for being off work. We call it temporary total disability benefits. Everything is going okay. Well, that's the informal process. Nobody's really done anything to force them to pay for this. They're paying for all this stuff voluntarily. So you don't really need an attorney right now because you're getting what you need. But during this process, you really haven't had to force them to do anything.
Well, let me back up real quick, because this is something that really, to get this process started, you are, as a worker, as an employee, required to give notice. Do you want to talk about that, just because there are some specific things that they need to do? It's not your union steward you need to be talking to.
And everything we're talking about here is related to Kentucky.
Yeah.
And other states are similar. But in Kentucky, you have to give notice of an injury to your employer as soon as practicable after the injury. That might be the same day it occurred. You may get hurt, not realize that it was actually at work, learn about it from a doctor 2 weeks later. Well, you got to give notice then. So you got to give your notice to the employer. That's actually how they start your claim. If you don't give notice, they're never going to start a claim. You're never going to get this informal process going. But once they get that notice, there's usually several things they have to do. They've got to report it to the workers' compensation insurance carrier, which usually requires the carrier to do some stuff, assign it to an adjuster, give you a claim number, get the case going. Sometimes they have to report it to the Kentucky Department of Workers' Claims. But that notice starts everything, starts the informal process.
And that claim number is awful important, isn't it?
Well, yeah, there's a couple of claim numbers that get involved in this, but the very first important one is the claim number you have with the workers' compensation insurance carrier. That's important for a couple of reasons, because a lot of these carriers aren't based in Kentucky anymore. You're dealing with somebody in Indiana who might be at a location that gets shut down and they move it to Atlanta, which might get shut down. You might be dealing with somebody in Cleveland. So, you've got to keep track of your case. The adjuster may change. The names of the companies change. Several of them changed here recently. But your claim number will always stay the same. So if you're having problems with your claim, you've got to contact the carrier. You've got to identify the claim number. Otherwise, you're going to be spinning your wheels for 2-3 days till everybody figures out what the claim number is. So when you get this claim going with this informal process, at some point in time, the adjuster is probably going to contact you, call you, send you a letter. They're going to give you this claim number. Don't lose that claim number. Tattoo it on your arm if you have to. There's a lot of cheap tattoo places now, but you want that claim number.
They do that while you wait.
They will too. Yeah, right across the street from me, as a matter of fact. But you really do need that claim number, because that claim number is the key to unlocking the door to the people that will make decisions about your case. Now, you're actually going to get two claim numbers. This is where it gets confusing. Your workers' compensation insurance carrier is going to have their own internal claim number. Who knows? You may work for a company that even has their own different claim number, but your workers' compensation insurance carrier is going to have this claim number that's going to unlock all the information with them. Now, when you have a claim in Kentucky, they also have to report that to the Kentucky Department of Workers' Claims, and you'll get a separate claim number from the Kentucky Department of Workers' Claims. That's going to be different from your workers' comp carrier. Why is all this important? Because you don't want to get these two claim numbers confused. It depends on who you're dealing with. With a carrier, you want to use their claim number. With the Department of Workers' Claims, you want to use the claim number that they assign.
And again, this is something you can help with if you're engaged early. But at this point, if things are going smoothly, maybe they haven't felt the need to actually engage in an attorney.
A lot of people are, everything's going the way it should. The workers' comp carriers contacted you. They've agreed to pay for this or paying for medical treatment. You're off work. You're getting money from them. It's coming timely. A lot of times that doesn't happen, and any of that stuff that doesn't happen is a reason to call me. But let's just assume all this is going the way it's supposed to. You've got what I call an informal claim.
Sure.
One going with the company, one going with the company's workers' compensation insurance carrier. Everything's going okay. Well, even though you don't have an attorney, you got to remember a couple things. Number one, they owe your medical treatment, but you do not have to go to the doctor they tell you to go to. I find it frequent that the workers' comp carrier or the employer would tell the employees that they have to treat with a specific doctor. That's not the law in Kentucky. The law in Kentucky is you get to pick the doctor. So even if you've got an informal claim, even if everything's going okay, a lot of times a company will try to save money by steering you to doctors they know that will save them money. And there's a lot of ways they can save them money. I'm not going to get into all that right now, but you have a right to go to the doctor you want to go to in Kentucky. Sometimes that's limited. If you're in a company that has what's called a managed care plan, which is like an HMO for workers' comp injuries, then you've got to go to one of those doctors. But the company can't tell you which doctor to go to in that plan. You still get to pick. So frequently I'm told by my clients that they've been instructed to go to a specific doctor because they had to. That's not the law in Kentucky. It might be in other states. The claims adjuster may have it wrong. The employer may have it wrong. But it saves them money for you to go to a specific doctor. What I tell my clients is you probably want to go to your family doctor who has your best interests at heart. Even though it's an informal claim, even though everything's going okay, the company's trying to save money by steering you to certain physicians and certain medical providers. The reason they're trying to do that is to save money. They are not as interested in getting you better. They are not as interested in making sure you're not hurting. They are interested in saving money. That's why they're steering you to these doctors. If you go to your family doctor, your own GP, that person usually has gone to medical school to try to help people, not to make sure the company saves money. Sometimes I'm wrong, but most of the time they honestly want to help you. They want to make you better. And if you can get your family doctor to be in charge of your medical treatment, that's some of the best legal advice I can give you, because you're stepping out of the systems they've set up to save money, which generally doesn't help you, and you're getting into the system now that's designed by your family doctor to make you better, which is what you want.
And even at that point, if you're a general practitioner, your family doctor still wants to refer you out to a specialist or something, and that's fine. That's fine. But start with your family doctor if possible.
There's a lot of things in the workers' comp system that try to save the company money. One of those things is they require you to designate a physician to treat you. They call it literally a designated physician. You've got to fill out a form. You've got to have your doctor accept it. And then you can only go to medical providers that doctor recommends you go to. For instance, if you're seeing Dr. Smith and you don't like the way he's treating you, you want to go see Dr. Jones, well, unless you switch medical providers, you can't do that. It's designed to keep you with one doctor, so you can't do what's called doctor shopping. Insurance companies hate that. They're afraid you're going to go to a doctor that eventually will say you need a surgery, it costs them money. So they want to restrict your right to go to doctors. Even though you can pick the doctor to go to, they want to keep you from going to any other doctor. Now, in Kentucky, once you designate a physician, you can switch that designation one time without a problem. A lot of carriers won't tell you can do that, but you can do that. Things happen. Doctors' offices get tired of dealing with workers' comp carriers. They may not want to mess with all the forms and the adjusters and rehab nurses and all that stuff. So, sometimes you have to switch doctors, and you can do that without a problem one time. Doing it two times, that's when it runs into a problem. That's a little bit more technical than probably this podcast. You need to talk to an attorney. But switching doctors is something you don't want to do if you've got a good doctor. Having a good doctor who wants to take care of you is vitally important in this. The carrier will try to steer you to medical treatment. They'll try to assign nurse case managers to go to the doctor's office with you to try to talk the doctor into not giving you medical treatment because it costs them money. A good doctor will ignore those nurse case managers, and the good doctor will require that nurse case manager to come in separately from when they see you. If a doctor won't see you unless a nurse case manager is there, you got a problem because they're more interested in making the nurse case manager happy. Maybe send them a lot of referrals than they are making you happy. Yeah.
So, and again, if all of this is working right, then you're probably getting some type of medical treatment at this time.
Yeah.
And so that there's a spectrum to that medical treatment.
Right. Generally, what you're going to find with a workers' comp injury is the medical treatment that costs less is going to be easier to get. So if you're seeing a doctor, you're getting a low-cost pharmacy, prescription filled, maybe physical therapy. Usually that's not very expensive for the carriers. It's a loss. They don't like it, but they're not really going to throw a roadblock in front of that. What you're going to find out, though, with the informal claim, even though they've accepted it, medical expenses are a big element of these workers' comp injuries. And when you're starting to look to get a surgery, when you're starting to look to get to some significant medical device like an implant or a brace, things that cost a lot of money, the carrier's going to look at those things real hard. And even though they've accepted this case, they still have a right to have that particular expense reviewed. And generally, the more expensive the expense, the more they're going to review it. Sometimes, they'll send you to a doctor that they know will say that you don't need this particular type of surgery or therapy. And the reason that happens is they're trying to save cost here. So even though the claim's been accepted, even though this is informal, you don't have an attorney involved in it, you may end up having to deal with this speed bump in the road of getting medical treatment. And a lot of times the carrier will say that's not part of this workers' comp claim. It's not an expense that you have to have. But that may not be the case. There's a standard the carrier has to look at. There's certain things the carrier has to do. They have to have it reviewed by certain parties. My experience is a lot of these carriers don't do what they're supposed to. And if you're having medical treatment reviewed, and even though it's an informal claim, you may want to talk to an attorney to see if that treatment is something you can actually get. We frequently deal with issues regarding medical treatment in these workers' compensation claims. In almost every case, it seems like there's an issue regarding whether or not surgery should be paid for. Again, the carrier's got to do certain things to get that denied. A lot of times they don't. If that happens, then, we probably have to file what's called a medical fee dispute. That's a fairly technical issue. You are more than likely going to need an attorney involved in that. But I think the biggest thing that you need to remember is that this medical treatment that they may be denying, you may actually be able to get. Another thing, too, a lot of times people have their own health insurance, and sometimes it's easier to have it turned into your regular health insurance than it is a workers' compensation insurance carrier. You can do that if it's been denied by the workers' compensation insurance carrier. Usually that's the fastest way to get this done. You've got co-payments and deductibles and things like that you have to work with if that occurs. And we can usually work out who has to pay who back. The workers' comp carrier has to pay your health insurance carrier back, and you for expenses you incurred at the end of the case. But sometimes that's easier to get this done than to file a medical fee dispute. A medical fee dispute is a formal process that we'll talk about here in a minute, similar to the other parts of the formal process. The biggest problem about a medical fee dispute is that will take a long time to get resolved. You have to file it with the Department of Workers' Claims. It gets assigned to an administrative law judge. Administrative law judge takes proof. The administrative law judge has a hearing. The administrative law judge allows parties to brief the issue, and the administrative law judge issues the decision 60 days after the hearing. So that can take usually 9 months to a year, depending on everybody's schedule. So if we file a medical fee dispute in your claim, we usually have a substantial chance of winning it, but the problem is there's about a year delay in treatment. Now, after you go through your medical treatment, let's assume that you've resolved all the issues that have come up, that you've gotten all the surgeries that have been disputed. You're still getting your money for being off work. At some point in time, you're going to meet this magical thing we call MMI, maximum medical improvement. Maximum medical improvement is what I call a magical point. That means you're not going to get any better and you're not going to get any worse. When you reach maximum medical improvement, the money the carrier's been paying you for being off work will stop. You might be entitled to more money, and this is generally what we argue about is how much more money you get. But the money you've been getting for being off work, they're not required to pay that any longer once you've reached maximum medical improvement. You may not be able to return to work. You may be totally disabled. You may be entitled to the same kind of money you were getting while you're off work. But at MMI, they don't have to pay you any more of the temporary total disability benefits. At MMI is generally when we start looking at your case and try to determine its value for the permanent problem. We try to get things like impairment ratings from the doctors. We try to get those from your doctor because usually your doctor's opinion about your impairment rating is going to carry more weight than any doctor I send you to. Sometimes doctors won't give us impairment ratings. Sometimes they don't do it right. We may have to send you to an independent medical examination to get that. Sometimes a carrier does that too. But we've got to figure out an impairment rating because that's a big element in your workers' comp claim about how how it determines how much more money you're going to get for your permanent problem. We've also got to figure out a couple other things too. We've got to figure out what your permanent restrictions are on your physical activities. That has a bearing on how much money you get. And we've also got to figure out whether or not you're able to go back to work at your old job, and whether or not, if you do, you make as much money as you did before. Again, all those things have a bearing on your case. And once we put all that together, we try to figure out what your case is worth, and we make an offer to sell it.
And ideally, at that point, the company looks at it, the adjuster looks at it, and goes, "Okay, that's fair. We see what's been going on. We've got the medical data, we've got the records, we've got the recommendations. Yeah, we're comfortable with that, and let's go ahead and settle this claim before we have to go into a formal process." This is really
the end of what I call the informal process, where we try to settle your case now for a couple of reasons. First of all, it's usually better for you. You get your money faster if we settle it. Secondly, you usually get more money because we don't have to spend as much money as we do in a formal claim. And most people want it over with, and we try to work out a settlement where you get your money in a lump sum. We can't force them to pay the money in a workers' compensation claim in a lump sum unless we work out a settlement. Sometimes we can settle these, sometimes we can't, but we try to settle it because that's usually best for our clients to do that when you've reached maximum medical improvement and we have all the information we need.
Well, and the other issue here is the adjuster may have his or her own independent medical examiner who has maybe a different impairment rating. Is that possible?
Depending on the severity of the case, the more severe the case or the more problem somebody has and higher the impairment rating, it's more likely the adjuster is going to send you to another doctor to get an impairment rating. And I tell folks, I can send you to 5 doctors and I can get 5 different impairment ratings for the same thing. Generally, the insurance company is going to send you to a doctor they know is going to be a little bit more conservative on the impairment ratings. I'm going to send you to doctors also who can get an impairment rating, and then also the treating doctor hopefully will give you an impairment rating. And a lot of times we have a range, and just to give you an example, we might get 5% from the insurance company's doctor, we might get 10% from the treating doctor, and we might get 15% from my doctor. So we've got a range of numbers. Now, in the scheme of things, usually the treating doctor's number is going to carry more weight with everybody because they're not paid by me or the insurance company come up with a number. So generally the administrative law judges put more weight on that number. Sometimes the treating doctors don't want to get to the point where they've got to learn the book that determines how you get impairment ratings, and they just won't do it. Some doctors won't. So we've got to work out some kind of a compromise between our numbers and their numbers. But this is where we try to work things out. We sit down, we evaluate the case, we figure out what it's worth. We make offers. Sometimes we sell it, sometimes we don't. But again, it's usually in our client's best interest to settle it right now when you've reached MMI, once we have all the information together. A lot of times, though, we can't. And when we can't settle, then we go to what I call the formal process, which is the fun part of it, which is more detailed, more attorney-driven. This is when you file a formal claim with the Kentucky Department of Workers' Claims. It's not a lawsuit, but it's similar to a lawsuit the way you file a complaint and you go before a judge. We file the formal documents with the Kentucky Department of Workers' Claims to start your claim. They'll accept those. They will then assign it to an administrative law judge. Once all that happens, then the attorneys start working on your case. Usually in this process, there's a period we call discovery. If you've ever had a car accident, it's fairly similar to that. We're going to exchange documents about it, you and the insurance company. We're going to ask, for all the documents related to your claim that we can get from the insurance company, wage records, medical records, if they've got any surveillance. They're going to ask for information regarding whether or not you've worked for anybody else, whether or not you've gone back to work, all the other medical records that might be in our possession they don't have. So we'll exchange documents. That's all done really outside of the eyes of the injured worker. We might need you to help compile these documents, but this is a process where each side is trying to discover a little bit about the case. Once that happens, then generally almost always there's a discovery deposition. That's when the insurance company will sit down and ask the injured employee a set of questions. And they're allowed to do this. There's not a set of questions, but, if you've done this long enough, you almost know what the questions are going to be beforehand. I will sit down and get my clients ready for that. We'll go over the possible questions that are going to be asked. We'll go over the things that are what I consider the problems or the things that need to be discussed in the case. We'll get you prepared for the deposition. The deposition will occur in an attorney's office, and that's a formal proceeding where you're sworn in and you're obligated to tell the truth, and they will ask you a series of questions. Generally, the deposition is almost always questions asked by the defense attorney. They're trying to find out information about your case that helps them. The whole purpose of this is to give them information that they can use to evaluate your case. They're hoping that you're going to have a prior motor vehicle accident where you injured the same part of your body that got injured at work. So they can argue that that's really what's causing your problem. They're going to try to argue that, there's some other thing that you can do. You've worked in the past in a supervisory position. Even though you can't do labor now, you can go back to that supervisory position, because if you go back to work and you're making more money, that saves them money in the long run. Anyhow, they're going to go through all these sets of questions at the deposition.
Well, and they may, and again, this comes down to something they may have turned up in the discovery process. Let's say you're on Facebook talking about your injury and how now you're going to take the grandkids down to the lake to go fishing, or maybe you're going to go to Kentucky Kingdom. Scott, there's something about social media people need to understand.
I hate Facebook. Because
although you have a really good business Facebook page.
Thank you. I appreciate it. I have to thank the guy that prepared that. But Facebook, anything you put on Facebook, there's public and private profiles, but even if you have a private stuff, you got friends and friends have friends, and anything that can be misinterpreted in Facebook will be misinterpreted. If you're hurt, I've had guys that got hurt, couldn't walk, but there was a picture of them sitting at the pool with a glass of rum. Well, that came up in the case because the claims adjuster couldn't believe that they were actually sitting around drinking when they were hurt. There's no law that prevents that, but what it does is it creates a whole lot of things in everybody's minds about what you are or not doing. Obviously, there's things where you will get in trouble with Facebook if you say you can't walk and there's a picture of you walking around the state fair for 5 hours.
I said nothing about the diving board. I just said I couldn't walk.
That too. Then that's going to cause the obvious problems.
Yeah.
Occasionally, I'll have Facebook help me. I remember one time I had a car accident case where this was back when I first started Facebook, like 10 years ago. The client had posted 30 or 40 pictures of a surgery she had. I didn't know she had pictures of it. She put it on Facebook, and it actually helped her case. But she never told me about the pictures, or she'd taken them. We actually use those. Occasionally it helps us, but generally it causes more problems than it solves. Yeah. If you've got a Facebook page, I guarantee you the claims adjuster and the attorney on the other side is going to be checking that out. If you've got a Facebook page that's private, the attorney and the claims adjuster are going to try to find a common friend, to where they can look at what's going on. So anything you post on Facebook, I would count on somebody on the other side looking at. And, you only want to post stuff up on there that you can explain. It causes a lot of problems in cases. Relatives, friends post stuff sometimes just joking that can be misinterpreted. I just don't like it because it's something out there. I don't like to get on other people's Facebook pages that I don't know, but that's going to happen. And I feel like I'm, walking in somebody's house, looking around for stuff that I don't need to be looking around for, but somebody's going to be looking at that and checking it out.
But coming back to this deposition, that information you're going to be asked questions about that. And especially if it catches you off guard, or they're trying to take it out of context or spin it a certain way, it can get complicated very quickly.
Yeah. Sometimes they try to save those kind of questions for the hearing. One of the reasons we go through this discovery process is we ask for information like that might pop up at the hearing, so you're not blindsided. One of the other things that comes up is surveillance. People are astounded to find out that the workers' comp carrier can have a private investigator videotape them. Well, in the United States, as long as you're on public property and as long as you're not trying to get in somebody's house, you can videotape stuff in the public. And it's not uncommon for me to get videotapes of my clients going into the doctor's office, because the carrier knows they're going to be going to the doctor at a certain time. So they know they're going to be out of the house, and they'll have private investigators follow them and videotape them. That doesn't come up all the time because it's fairly expensive for the insurance company to do that. But it's important for everybody to know the carrier has a right to have you followed, videotaped, investigated. And that becomes important because at your deposition, you got to tell the truth. And at the deposition, if you say, I never go swimming anymore because of this injury, and then the investigator's got a picture of you at Sun Valley Pool jumping in the pool, we got a problem.
Yep.
A lot of people forget the main thing is to be truthful. Most of this stuff can be explained. Usually the investigator's following this person around for one day. It's not like 8 hours at a job. But at the same time, we need to be truthful about everything. We also need to understand that they have the right to have folks investigate you and do surveillance. But we try to find that out. Normally, that's not usually a huge problem. Every now and then it is, and we deal with that as it comes up.
So we're still in the formal process. We've done discovery now. We've had some depositions. Where does it go from there?
Okay, after the discovery process is over, after we've gotten all the information together, doctors' reports, and a lot of this stuff is going on you don't see. We're getting reports from doctors. You may not be there when we get them. We may have vocational evaluations performed depending on what's going on with the case. But we'll get all this information together, and then we'll submit it to the Kentucky Department of Workers' Claims as evidence in your case. I think I had a case this week where we probably had 40 or 50 entries, which is more than almost every other case I've ever been involved in. And if it was paper, it'd probably be 4 or 5 feet tall. So we'll submit that. A lot of times the client doesn't see all that paper submitted, but it's in your record. And all that is stuff that the administrative law judge will review to make a decision. But to get to the point where the administrative law judge does that review, we have to have a hearing. The hearing is really the only chance you're going to tell the person that makes a decision in your case what happened and how you're doing. In workers' compensation, we don't really have trials where we have a jury. We don't go into a formal courtroom where we do voir dire and have opening statements and then present evidence and then have closing arguments and then have a jury decide.
It's not what you see on TV.
No, not in a workers' comp. It's an abbreviated version of that. The equivalent of a trial in workers' compensation claim is a hearing. And it's a very informal procedure compared to a trial. There's no bailiff. The judge doesn't wear a robe. The judge has got a suit and tie on if it's a man, well-dressed if it's a female. They'll be sitting at the end of the table. I'll usually sit next to the judge, and my client sits next to me, and on the other side is a court reporter typing everything down and another attorney. So every now and then we have some company representatives and family members, but usually there's only about 4 or 5 of us in the room. And it's usually a 30 or 45-minute proceeding depending upon the administrative law judge, where basically you get to tell the judge how you're doing. This is hard for a lot of my clients because they've been living with this for 3 or 4 years, 5 years sometimes. Yeah. And, ups and downs, people have accused them of things that weren't true, saying they could go back to work when they couldn't. They're hurting, significant injuries. And, it's not like a 3 or 4 day process of a jury trial where you kind of flush this all out of your system. It's only about 30, 45 minutes. The judges only give you that much time because a lot of the evidence has already been submitted in your case. The things they really look at are the doctor's reports, medical reports, about opinions about whether or not it's work-related, impairment ratings, restrictions, return to work. A lot of the stuff they use to determine your case is already on paper in front of them. The hearing is really just your chance to explain to the judge, for them to size you up, to let them know whether or not you're telling the truth. That's your chance to explain your story. There's a lot of stuff my clients want to tell the judge. We've got to get prepared for the hearing to make sure that we give them the information the judge really needs, which is how you're doing. Let the judge size you up. A lot of times how the injury occurred is not a big deal. If the employers accepted it, believe it or not, how you got injured is not a big deal.
Right.
Because, if you got hurt at work, you got hurt at work. It doesn't matter how you got hurt at work unless it has some bearing on your medical treatment. But if you got hurt at work and they've accepted it, we may not even talk about how the injury itself occurred because that's not a big deal. They've accepted that. What's really big in your case is how you're doing, because the judge has to decide which one of these doctors' impairment ratings right. Is it the small one from the insurance company? Is it the higher one from my doctor? If the judge thinks you're doing okay, guess which impairment rating he's going to give you? If the judge thinks you're not doing okay, he's probably going to give you a higher impairment rating. So that becomes very important in this, is to let the judges know how you're doing. It's hard on my clients. It's hard on me because you've got 30, 45 minutes to do this.
Right. And that's really all you have in terms of your day in court.
Yeah. And the other part about this is, can I ask for more time? But the judge has got 300 or 400 cases, and when they do hearings, they do them usually one day they'll do hearings every 30, 45 minutes apart. Wow. And it's not an assembly line process, but they have to stay on schedule, because if our hearing takes 15 minutes longer and the next hearing takes 15 minutes longer, well, the judge is already 30 minutes behind, and at the end of the day, they're going home at 9 o'clock. So we've got to be short and sweet with the hearing. We've got to give the judge what they need. We've got to keep them on time. Otherwise, the judge is not going to appreciate that fact. And remember, we want the judge to like us, not be mad at us. So this hearing is really important. The shame about the whole workers' comp process is it's so short and sweet. You only get one chance to meet the person that's going to be making your decision. I think we're very fortunate because we got a lot of good judges in the system right now. They all want to take the time to listen to the folks. They all understand what these people go through. I think a lot of times my clients got to explain a lot of things the judge already knows. The judge knows this is a hard process. They understand everybody's going through the same thing. A lot of these judges, almost all the judges, have been former attorneys that handle this either from the defense or the plaintiff's perspective, so they know the underlying stuff. And all these judges are extremely competent, so they can read between the lines in a lot of these things. For instance, a lot of these doctors that are used, they've seen before, and they understand how the treatment is going to be determined by the doctors and impairment ratings. And this is not like a jury where you've got 12 people that have never seen this particular accident before. These judges know this stuff, if not the same, better than I do, and they deal with it all the time. So they can cut through a lot of this stuff and figure some things out fairly quickly in these cases. But again, to me, it's a shame that the hearing only takes 45 minutes because my clients have been living with this for a long period of time. And just being able to talk about it, I think, helps folks a lot of times. Now, after we have the hearing, then the fun really starts from my perspective. The judge will generally give both parties 30 days to write briefs. That means he will not usually issue a decision at the hearing.
Really?
A lot of folks, it's not like a trial where you get a decision at the end of it. You go to the hearing, and I've got to explain this to my clients. He's not going to normally issue a decision right there. Every now and then it happens, but it's actually pretty rare. So we'll go to the hearing, then the judge will give us 30 days to write briefs. That means me as your attorney will write a brief that we will submit in front of the judge to argue your case. The other side will do the same thing. The judge will then take those briefs, go through the whole file, and 60 days after the hearing, issue a decision. Now, once we get that decision, we're going to know what the judge thinks. There may still be some things that have to be polished up because there's a lot of math involved in these, and every now and then some of the equations get messed up. So we'll have to go through the decision just to make sure all the math's right. But once we get a decision from the judge, then we've got a pretty good idea, obviously, of what the judge is going to do and what you're going to get. The big question is, after the decision comes from the judge, will it be appealed? Because even though you get this decision from the judge, even though you lived through this thing for 2-3 years, filed a claim for another year, and got a decision from the judge's decision can be appealed. We can appeal it. The other side can appeal it. Usually, there has to be a reason for appeal. We just can't appeal because we don't like the decision. There has to be something wrong with the judge's decision. He ignored some piece of evidence. He did the computations wrong. There was a case he relied upon that's not supposed to be relied upon that way. If there's something like that, we can appeal the decision. If the judge decides that Dr. Smith's impairment rating is the one he's going to take over Dr. Jones, we can't do that. We can't appeal that. That decision about which doctor to use is strictly the judge's decision, and we've got to live with that. A lot of times that's the biggest issue in the case, which impairment rating to use. But the judge has the authority. As long as the judge has looked at both impairment ratings, as long as the judge has acknowledged that they're both out there, she gets to pick which one they want to accept. And there's really not much we can do as far as an appeal after that issue. But assuming that there is an appeal, what happens next is it goes then to the Kentucky Department of Workers' Claims Workers' Compensation Board. And this is a panel of 3 attorneys that will then review the administrative law judge's decision. This usually takes about 9 months for that appeal process to go through, which is hard because a lot of clients are trying to get the case resolved, and now we got another 9 months on top of that.
Well, Scott, let me stop you there for a minute, because I'm hearing all these extensions and all these timelines, and I'm thinking, well, okay, we've gotten already to maximum medical improvement. We've gotten to the MMI. Ideally, they've got an impairment rating of some sort. Are they still getting paid during this time?
It depends on what's happening with the case. If for instance, we're arguing over a 25% or a 20% impairment rating, generally you're going to go ahead and get the 20% impairment rating, and the difference between the 20 and 25% we're going to be arguing about. So you'll get some benefits. Now, I've got one case right now that's appealed that the person got total disability. They're getting their benefits that they're supposed to be getting. What we're arguing about is the length of time they're supposed to get them. The carrier is going to be arguing that because of some amendments, the benefits stop at age 70. I'm arguing that the benefits stop when the person dies. So if they reach age 79, they continue.
True,
right now the benefits are going. Yeah. But when they turn age 70, because we're arguing from that point off, they'll stop. And unless the courts decide they get benefits after that point, they're not going to get any more. So if there's anything that's not in dispute, The undisputed things will continue during this process. The disputed things won't. If, for instance, we're arguing about whether or not there was a work-related injury, if that was a dispute, and if that was the issue that was appealed, whether or not the judge didn't consider some evidence about whether or not it was work-related injury. If that's the issue, because if it's not a work-related injury, you don't get anything, then the person's not going to get any benefits. But if we agree there's a work-related injury, if we agree they have an impairment rating, the things that we agree on will continue. But a lot of cases, that's the big issue, is whether or not somebody got hurt at work. So in that situation, they're not going to get any benefits till the appeal's resolved. And the unfortunate thing about appeals is there's 3 levels of appeals after the judge's decision. There's the Kentucky Department of Workers' Claims, appeals to the Workers' Compensation Board, which take about 9 months. That can also be appealed. From that point, you go out of the workers' comp system to the Kentucky Court of Appeals, which can take 3 months to a year and a half, depending on the issues. Usually about 9 months to a year is about where those fall. And guess what? It can be appealed from that point to the Kentucky Supreme Court, which, again, depending on the issues, takes 9 months to a year. Now, the Kentucky Supreme Court decision can also be appealed to the United States Supreme Court. I'm unaware of any workers' compensation claim from any state, though, make it to the the United States Supreme Court. In the last 50 or 60 years, that's usually a state-specific issue that the United States Supreme Court won't get involved in. I think it almost would be futile to file one to the Supreme Court. There probably are some issues that could come up right now. Actually, we have a constitutional issue that would be one of the rare things I think that would go to the United States Supreme Court. But for most issues in a workers' compensation claim, your last court of resort is going to be the Kentucky Supreme Court. So after you get the judge's decision, you can add 9 months to a year to 3 levels of appeal after that before you get a final decision. Now, if you're not getting benefits during this period and you win, they owe you interest.
Nice.
And I had one case that got appealed to the Supreme Court where we got the client about $10,000 that was just interest in past due benefits. Now, the interest rate's gone down since that happened. I think it's 6% for most cases now. But they do owe you interest. So you could end up winning, and then they owe interest on the past due benefits.
This is almost like getting back pay, really.
Well, you essentially get the back benefits, and then there's past due interest on the back benefits.
Yeah.
So that's one of the few elements I've seen taxed too, the interest, but the benefits themselves are not usually taxed. But, you do get interest on the benefits. And again, it's 6% right now, which is better than what you get if you put it in a bank. And probably even the stock market, since this is going down so fast. But you do get interest on the benefits.
Yeah.
So that's kind of the process. We've got the informal process where, a lot of times it gets started without me as an attorney having to push anybody. There's a couple of speed bumps in the way as you go through it, especially with medical treatment, making sure they're paying you the right amount, stuff like that. And at the end of the informal process, like I said, we generally try to settle the case because that's in our client's best interest. But if we don't, then we got to go through this formal process where we actually go before a judge. We do the litigation, depositions, discovery, hearing, briefs, decisions, and appeals.
Yeah, so I mean, it's not a quick process.
Unfortunately,
the informal part can be relatively quick.
Yeah, the informal process really depends on whether or not we can agree. This is a little bit different than, say, a car accident, because in workers' compensation, we got to wait till you get done with the medical treatment before you get MMI before we can figure anything out. In car accidents, they can kind of project that out. But a lot of my clients, are going through medical treatment. They have a surgery. It takes 6 to 9 months after the surgery. It might take them 6 months to have the surgery. So it might be a year and a half before we reach maximum medical improvement after the injury. And then that's the only time we can really figure out what the case is worth.
But in most cases, I would imagine you're still getting that temporary total disability, that TTD payment.
Yeah, that's the one thing is if they haven't accepted it as a work-related injury, if they're not paying temporary total disability benefits, if they're not paying medical expenses, then we just short-circuit everything and move it to the formal process.
Yeah.
Because there's no sense in waiting. If they're not paying for it, we're going to have to argue about this stuff anyhow.
Right, expedite everything and go.
We just get a judge to decide that, for better or worse right now. Sometimes we have to put them in abeyance until you reach maximum medical improvement. We're getting real technical here again. But if we can't get the things that you normally get in the informal process, money for being off work, medical treatment, if they've turned the case down, then we don't have any choice but to move it into the formal process, file a formal claim.
Yeah. Scott, this has been a really, really informative episode, because I think a lot of people just don't know what this overall process is going to entail. But it's always good when you're looking at it to kind of understand, okay, it could go long, but there are ways to get you some help while we're waiting. And, you've got years and years of experience. If somebody does want to get in touch with you and say, Scott, I think we need to talk, what's the best way for them to get a hold of you?
Usually my phone at the office is the best way to reach me. It's 502-937-5287. And if you call, we'll generally have the staff members talk you through this, and you'll usually end up talking to me if I'm available. A lot of times I might be in some other matter, a hearing, deposition. I may not be available that day, but I'll try to get back in touch with you as soon as possible, usually within the next day. So if you call my office, eventually you will talk to an attorney, usually, if not that day, the next day or so.
Well, and if you have further questions, feel free to visit Scott's website. It's got a ton of information and blog posts and other links to previous podcast episodes. And you can find that website at ScheynostLaw.com. That's spelled SCHEYNOSTLAW.com. Well, that's a wrap for episode 6. We appreciate you taking the time to listen. Scott, thanks for your time, buddy. And we'll be back in 2 weeks. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST Law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.